In a very interesting one. We ask for your continuous guidance as you take us through these proceedings so that we can finally get to our destination. In your precious name we pray. Amen.
Thank you, Senator Gill. First of all, apologies for absence. Senator Lambert Brown sent an apology. No other apologies. He's on his way. Right. Senator Charles Sinclair should be. Okay, so there are two persons who should be here shortly. Also welcome the Attorney General's Chambers, SG and Ms. Masada are here. The Children's Advocate, welcome Ms. Gordon-Harrison. The MOJ team is here, Mr. Paul Bailey. CPC is here. The Law Reform, Mr. Simmons and Ms. Wright are here. And we have Ms. Bailey, we have from the Ministry of Education, two persons. All right, we are from the Ministry of Education. We also want to welcome colleagues, the children from Tomlin's Christian Academy, St. Anne, welcome, and their teachers, and also Everettville Primary from Clarendon. Welcome to the sitting of the Joint Select Committee. Colleagues, I know we have 2 minutes, which again we are going to put, because maybe you just got them, so we might have to do them if time permits at the end of this meeting. Or we put it, because I did not see them, I must admit. They were only sent out yesterday, so it's possible that members have not seen those minutes. And therefore we're going to continue with the new business, the review of the bills. Colleagues, I'm proposing that we finish the matrix, which dealt with section 42, which should take more than a few minutes. So if you have the matrix at page 11, we're going to go through the matrix, and then I'm going to suggest we look at those two first bills, that is the one dealing with section 42, and also with the increase in the minimum mandatory reserve for capital and non-capital, which hopefully won't take too much time. And then we can come back to the question of the sentence for children. So, if I may, I'm going to proceed with the matrix at page 11. And the Office of the Children Advocate in Section 42E of the Principal Act, it is recommended that the proposed amendments to Section 42E3 and 42F, which have sought to increase the minimum term of imprisonment in each case, a proviso which speaks to a similar formulation of words for minors, be incorporated. That's something we will look at when we get there. I'm not too sure how we would do it, but CPC, please let us know how that could be done. In Jamaicans for Justice, the recommendation, amend section 3, section 42F of the Principal Act is amended by deleting the words, quote, a term of life imprisonment shall be deemed to be a term of 30 years, and substituting therefore the following, a term of imprisonment shall be deemed to be a term, A, 40 years where the offense is murder, B, 30 years where the offense is an offense other than murder. We are going to adjust that somewhat when if you don't mind me indicating to colleagues, when we look at 42F, for murder, the likelihood is that life imprisonment, we are going to recommend that it is somewhere in the region of 50 years. Is that right, Mr. Bailey? So that it is consistent with the other subsections. The Office of the Public Defender, the change being proposed could be a major disincentive to a defendant wanting to plead guilty. In the result, there is no doubt that it will have a long-term impact on the prison population. The lack of capacity for large intakes in our high-security prisons, St. Catherine Correctional Center and the Tower Street Adult Correctional Center is an established fact. The conditions at these institutions are notorious and do not foster a meaningful rehabilitation. It is our recommendation that as an incentive to the increase in stated statutory minimums, it may be more appropriate to maintain the 30-year minimum for non-capital murder and recalibrate the scale in the tiered system for persons pleading guilty, as is created in Section 42E2 as follows. Replacing the existing 33 and a third reduction with a 25% discount, replace the existing 25% reduction with a 15% discount, replace the existing 15% reduction with a 5% discount. Continuing, a look at the Parole Act, in particular, Section 6, may very well be warranted as the proposed mandatory minimum is in contradistinction to the sentencing regime recognized for parole consideration. That is the Office of the Public Defender. The Office of the DPP is quite extensive and takes us almost to the end, and probably the last one, main one to be considered. So we just go straight through. With the Office of the Director of Public Prosecutions, Section 42E, proposal. The proposed changes comprise an amendment of Section 42E3 to delete the words the prescribed minimum penalty for the offenses as provided for pursuant to Section 3(1)B of the Offenses Against a Person Act and substitute, therefore, the words 30 years. The effect of the proposed amendments. The amendment simply provides that the court shall not impose a sentence less than 30 years, thereby removing the applications of the provisions of Section 3(1)B to the sentence to be imposed upon a plea of guilt. The effect of the amendment will be to increase the minimum sentence from 15 years to 30 years. However, it has removed the two options available to the court under Section 3(1)B, that is, life imprisonment or alternatively, a fixed term of imprisonment. The minimum pre-parole period and the exclusion of Section 6(1) to 4 of the Parole Act to these. Therefore, a vital aspect of the sentencing regime has been removed, as the proposed amendments ignore the fact that the prescribed minimum penalty stipulated currently allows the court to impose either life imprisonment or a determinate term of a specified term of years that is fixed at a mandatory minimum. The discretion of, page 12, the discretion of a sentencing judge in determining the pre-parole period has also been affected. Therefore, a vital aspect of the sentencing options has been removed. It seems as though in removing the pre-parole discretion from the judges, the provisions of the Parole Act will now apply. That is the mathematical formulation contained in the Act. This is a serious omission, stroke erasure, because these provisions operate together to address the multiple facets of the procedure and consideration in sentencing persons for murder, whether tried or pleading guilty. They cannot be ignored by the court, and most certainly not legislatively. Recommendations. Therefore, it is our recommendation that the proposed amendment to Section 42E is sufficient as it relates to murder not falling within Section 2(1) of the OAPA. However, the existence of capital murder or murder falling within Section 2(1) cannot be ignored, as persons have in the past and will continue in the future to plead guilty in capital murder. Therefore, it is on that basis that we are recommending that there be a further amendment to Section 42E to stipulate how discounts are to be added based on a guilty plea to capital murder and what the minimum sentence should be that the court cannot go below when a person pleads guilty to capital murder. We're recommending that the proposed minimum sentence be 40 years. Continuing on page 13, Section 42F Criminal Justice Administration Act proposal. The proposed changes comprise an amendment of Section 42F to delete the words "a term of imprisonment shall be deemed to be a term of 30 years" and substitute in the words a term of life imprisonment shall be deemed to be a term of 50 years where the offense is murder, 30 years where the offense is an offense other than murder. I beg members to just make a note of that particular recommendation of the DPP, okay? Effect, the distinction between the categories of murders running throughout the Offenses Against a Person Act and evidenced by sections 42C is not accounted for, as there is no distinction between persons who are being sentenced for murders that come within section 2.1 and section 3.1a, and those which are capital in nature, and those which come within section 2.2. Currently, we see the distinctions recognized by section 3.1a and section 3.1.1ca of the OAPA provide sentencing options of death or life imprisonment for capital murders. In the case of sentence of life imprisonment, in this case, the minimum pre-parole period is not less than 20 years. In the case of other murders, the sentence of life imprisonment or term not less than 15 years. In the case of murder falling outside of the ambit of capital murder, when life imprisonment is imposed, the pre-parole period is not less than 15 years, and in the case of any other sentence, a pre-parole period of not less than 10 years. Sections 3.1b and 3.1.1cb. It seems there has been an omission having regard to the proposed amendments of the OAPA, in particular that to section 3.1.1ca, which increases the minimum pre-parole period when life imprisonment is imposed in cases of capital murders from 20 to 50 years, and the increase in respect of other murders from 15 years, where life imprisonment is imposed to 40 years, and from 10 years to 35 years in respect of other sentence. Recommendations. The perceived omission can be remedied by listing the applicable minimum period according to the various types of murders. Therefore, the particular portions in respect of murder could be amended by breaking apart into 3 sections, that is 50 years where the offense is murder, to which sections 2.1a to f or section 1a of the OAPA applies, 40 years where the offense of murder, to which sections 2.2 and 3.1bf apply, and 35 years where the offense of murder, to which sections 2.2 and 3.1b2 apply. That is in relation to section 42F. In relation, at page 15, we can go, which is the last page, and this deals with the amendment of section 3 of the Principal Act. The Office of the Children's Advocate recommend that the various subsections, sorry? Yes. Didn't I read it? No, when we get to 15, it is dealing with section 3. So we restart, because if you look to the left, right, this is, right. So we finish with 42E. And so we are now going to section 3 and page 15, okay? And it is, the Offense Against the Person Act amendment. So the Office of the Children's Advocate recommended that the various subsections of section 3 cited for amendment incorporate words to the effect of save in circumstances where the person convicted is a child. This would make the provisions consistent with the recommendations and justification discussed in relation to the Child Care and Protection Amendment Act 2023. I'm not too sure, Mrs. Gordon-Harris, we need to do that, because once it's a child, the Child Care and Protection Act takes over. So I mean, SG, you can advise us, or CPC. I don't think we need to say save and except where the offender is a child. Because once it's a child, it is the Child Care and Protection Act that applies. That's my, we can discuss that after. The Jamaicans for Justice recommended legislative proposal is to insert special provisions, the Offenses Against a Person Amendment Act, which exempts mentally ill and intellectually disabled persons from mandatory sentence and finds alternative to bring restorative justice to victims and care and possible rehabilitation to the ill offender. Legislative proposal insert in Section 2 of the bill. Section 3 of the Principal Act is amended by inserting in subsection 1C, the court does not have to impose a minimum term when it is of the opinion that there are particular circumstances relating to the offense or the offender which would make it unjust to impose a minimum term in all the circumstances, or it considers that there are exceptional circumstances relating to the offense or the defendant to justify not imposing the minimum term. Legislative proposal reduce starting points in the bill based on aggravating factors. Section 3 of the Principal Act is amended, A, in subsection 1B by deleting the word 15 and substituting therefore the word 25. In subsection 1CA by deleting the word 20 and substituting therefore the word 35. In subsection 1CB1 by deleting the word 15 and substituting therefore the word 20. D in subsection 1CB2 by deleting the word 10 and substituting therefore the word 15. Then the Office of the Public Defender said, in relation to the proposed amendment, the proposed increases outlined in the bill range from 260 to 350%. The proposed percentage increases are extreme. The proposed increases are, however, consistent with the legislature's express intention to increase the mandatory minimum sentences for murder to make it especially punitive. It is, however, not one that the OPD supports, bearing in mind our infrastructural issues and the lack of ability to provide meaningful rehabilitation to our incarcerated. Consider the newly proposed paradigm. It may be prudent to look at Section 6 of the Parole Act to assess the impact, if any. The Office of the Director of Public Prosecutions, let me just finish the reading and then we'll go back to it. No, just let me finish reading and then we can go back to each one, if you don't mind. The changes proposed involve an increase of the minimum sentences which can be served for the offense of murder with variation according to the types of murders recognized in the OAPA. There is nothing which prima facie appears to be in discord with the relevant laws and procedures. However, homage should be paid to the fact that the prosecution now enjoys the right of appeal and in recent times have played an integral role in the sentencing process by way of submissions and the procurement of victim impact statements. The importance of this active role now being undertaken by prosecutors is to highlight the need for flexibility in the sentencing exercise, as depending on the nature of the offense, the offender, and the public interest, the submissions may vary. Minister Williams, you want to go back to that question? Turn. Yeah, go ahead.
Mr. Chairman, just in general, for those persons or entities that argue about the infrastructural issues and the lack of ability to provide meaningful rehabilitation, are they really saying because these things are not in place, we should not impose longer sentences, harsher sentences? Is that what they're arguing?
There's no doubt that quite a few of the submissions took the view that by imposing minimum mandatory, we will be sending persons to prison to increase the prison population, which is already overburdened. So the fear of many of these presenters, including the Office of the Public Defender, is that the minimum mandatory is going to cause the prison system to burst even more. That's my understanding. Am I right, colleagues? I think they were making that point. Yes, that was their point.
Mr. Chairman, that's a totally different solution, though.
There's no doubt about that.
There's no connection.
No.
I mean, the prisons are bursting at the seams.
I-
That's a different solution.
You see, there's no doubt. There's no doubt. You see that the prisons, we have a great need for more and better prisons. That is undoubtedly the case. Yes.
Chairman, I'm a little surprised that we don't understand what is happening in the prison system. We know that we have not, I don't think we have one good prison in this country. When I said good prison, I'm not talking about luxury. I'm talking about with all the amenities to make sure that we can reform people, for them to live into a condition that is not too inhumane.
Yeah. But to be frank, and I've visited many prisons across the world. In my time, when I visit countries officially, sometimes I take the opportunity to visit prison. To the best of my knowledge, you have very, very few prisons that reform anybody. The main focus, I dare say, of prisons is security. That's the main focus. There are now some countries I hear where indeed some form of rehabilitation can take place. I know in England, they tried it with Borstal institutions, tried it with a number, but no one can say that in Britain. I visited several prisons in Germany, Germany and some other countries, and there's no doubt they try for rehabilitation, but to the best of my knowledge, they gave up. We can get to that situation, like Singapore, where Singapore now, the Chief Justice informed me, I didn't go to the prison, but he went to visit the prison, and he says that most of the prisons are air-conditioned. And indeed, persons in the prisons are employed in the prison is a call center. They work like a BPO. And in fact, most of the persons working in the prisons in Singapore have masters and doctorate because that's the stage where they're at. Now, in all my studies, I think it was Alexander Patterson, a criminologist or a prison governor, who said, sadly, the state of our prisons is a reflection of the state of our civilization. And there's no doubt we have a far way to go in Jamaica. I can tell you that. I can tell you, I used to visit district prison, GP, on many occasions as part of research I was doing. And it is just to visit these prisons is, not only stressful, but when you see the conditions in which the warders have to work, when you see how even the rooms that they allow for you to interview, as you members of the legal profession will know, it is just very heartrending. Now, I'm not denying that you have two fairly reasonable prisons, Tamarind Farm and Richmond Farm. But district prison and GP, believe me, are sad reflections of what we call prisons. Fact of life. Senator, you want to say?
Thank you for those remarks, Minister. I had to remind some listeners the other day that you did teach me criminology when I was at the Faculty of Law.
And you didn't suffer too badly from it.
No, but I think sometimes, until this morning, I thought you had forgotten the topic. I really want to ask the legislators who are here in the room, and indeed, members of the technical team, if they have ever been to a prison, if they have ever really walked inside a prison and seen the conditions under which the people exist. When I go, and I must confess that I try not to have to go, Indeed, when I was in very active practice, I was a bail specialist because I told them I'm not going to no prison to interview my clients, so they have to get bail. The conditions cannot do anything but dehumanize that person. And those of us who practice in the criminal law will be able to tell you that the person who is first apprehended and the person who you see 3 weeks later are simply not the same person. That the fear, the vulnerability, when they are just apprehended, is replaced by a kind of braggadocio, bad man attitude in 3 weeks, 3 weeks. You know, I think that we have to, Senator Sinclair, do you agree with me? I think we have to look and see. You said, Minister, that the state of the prison reflects the state of the civilization. And I hope that we here will not judge Jamaica's state by the state of the prison, because that would be an indictment on all of us, that we have allowed the social degradation of our country to reach the point where we are reflecting the prison conditions. That, for me, would be extremely sad.
I must say...
But I just want to say, because I'm going to get a chance to comment, I really want to know how many of our legislators have visited the prison and how many understand the extreme level of overcrowding and the inhumane conditions which presently exist. And how many of our legislators understand that with mandatory minimum, you're swelling the prison population when it gets to conviction.
I must say, though, colleagues, unfortunately, it's a different discussion. We have to compartmentalize our mind. No, but sentimentally, you can. No, I am not too sure that this committee can deal with the unfortunate conditions in our penal institute. We can make any recommendation, but at this time, we have to compartmentalize our mind and deal with the issues before us. I'm not denying, and don't get me wrong. I really believe much more should be done to improve the conditions everywhere, including the prisons. Fine? But we, because, all right, go ahead.
I can shorten the conversation by asking one question. So the government and the legislators are not supposed to be concerned about the possibility of rehabilitation, and we're not in this. Hold on. I just want to be clear. So what is it that we are trying to do then? We're just trying to punish.
No, let me just say this sentimentally. We're not going to solve all the problems in this Joint Select Committee. And that is why, even when I hear arguments about children, we must look to their background, which era they come from, what was their family background. These are considerations which undoubtedly should be taken into account. But we can't solve them here. We can't solve them here. No, the question of the legislature, we have to look at whether the sentence of the court or the sentence we want to impose is reflective, in my view, of the legislature's consideration about persons who commit murder. Because at the end of the day, this is why this bill is here, and it has to be supportive of the fight that we have against the offense of murder, which is so prevalent across every corner of Jamaica. Yes?
Minister, I share the concerns Senator Scott Motley has expressed, and I also share your position in terms of the need to address the issues that we are facing in terms of crime in the society. I don't think, though, that as legislators we have the luxury of compartmentalizing anything. I think when we sit in the people's house, we have to be concerned with all those things that touch and affect the people. But our purview under these amendment bills is to amend provisions dealing with sentencing periods. What we can do as a joint select committee is indicate in our report the issues that have come to the fore as a result of the engagement of the stakeholders and ask the Parliament to have that discussion in the debate and send a message to the executive that these matters need to be addressed. That is within the purview of the legislators,
Sure.
and I think is something we must be concerned about, because in instituting mandatory minimum sentences, it is relevant what is going to happen to that offender when they enter the penal system, because not all of them will sit there and die there. They're going to come back into society. So we need to be concerned with what is happening in that process. So our report can include some indication to the Parliament that the Joint Select Committee is concerned about the state of the penal system and would wish for the rehabilitative programs there to be robust programs designed to rehabilitate and not to foster a culture where we end up with people coming out of the system being even more of a danger to society than they went in. I think that we can do that with the report.
I think Senator Golden Campbell, you're totally correct. And Secretary, there's no doubt that the Joint Select Committee should take note of many of the issues different from what we're dealing with, but affect what we're dealing, such as the fact, when you look, by the way, there is a report from the questions were answered by the correctional services. It was put on your desk. It's on your desk. It should be on your desk. And one of the things you can note, and which the correctional officers noted last time, firstly, that many of the offenders are basically illiterate or performing at an educational level way below their age. All of these can be noted, that many of these offenders may have come from broken families. A lot of the concerns can be noted, including the fact that our prisons are overcrowded, and definitely the country should address. And by the way, this has been going on for the last 40 years, that we need to address the prisons. We need new prisons. There's no doubt about that. These two main prisons, St. Catherine and General Penitentiary, are over 100 years. And there can be no doubt they are just not reflective of what a modern prison should be like. So we can put in our report the urgency of prison conditions being improved, so that even though we send persons to prison as punishment, it should not be for punishment. And I say this because when you have to live in those conditions, you're really getting some serious punishment living in the conditions that our prisons have. But as I say, colleagues, we can note it in our report, but I dare say it really should not affect what we have to do in terms of what we propose. Now, colleagues, we have some complex stroke simple decisions to make. It is a fact why this bill was brought by the Minister of Justice, acting on the instructions of the Cabinet, is that murder is a serious problem across Jamaica. And we are trying, there's no one solution. And I would be the first to tell you that I don't think even the death penalty, if we decide to reimpose it again, that it is going to solve the problem that has been tried before. but we have to really tackle the problem of murder from all angles. Because at the end of the day, Jamaica cannot continue to tolerate the level of criminality, violence, and murder which we have in the country. And so this Parliament, this Joint Select Committee, in its report to Parliament, and Parliament, when it finally makes the decision, need to emphasize that we are trying, at least in the question of penalties, to send a signal to the country and to potential offenders that what you're doing must stop. That's the most we can do. So, in relation to capital murder, colleagues, at the moment, the penalty is, this is not for children, I'll come back to children shortly. But in relation to capital murder, it's either death or life imprisonment. We have proposed that if life imprisonment is imposed, that the person should serve at least 50 years if the judge so decides. The judge, in many of these capital murders, the judge frequently say life without parole, because remember the alternative is death. But we are saying that there could be cases where the court says life imprisonment, but you will serve a minimum, and the proposal of the bill is 50 years. What is the position of members in relation to this particular minimum mandatory for persons convicted of capital murder? Now, I want to emphasize, colleagues, one of the reasons why it should be stiff and stern is that if they want to any form of mercy, they can, obviously if they're not guilty, they must plead not guilty. But if they're guilty, you can negotiate with the prosecution under the Plea Negotiation and Agreement Act, or you can come back to the Criminal Justice Amendment Act. We'll come back to that in a moment, okay, the Criminal Justice Amendment Act. But I'm saying that I suspect that persons who are guilty of capital murder, that they must serve a long period of time before, it can be life without parole, okay? The other thing we should note, colleagues, is that once they get life imprisonment and they serve an extended period in prison, in an institution, let us say they served 50 years, they were 18 years when they were convicted, so they are now 68. If they go out and breach the condition of their parole, because it's life imprisonment, they can be sent back to the prison. You get me? So bear that in mind. Yes, you want Minister, go ahead.
Right, so just a question, Mr. Chairman. So by going to this 50 years, we're actually making it lighter, right? Because it's death or life imprisonment without
You know,
parole.
to be frank with you, the few cases that I've seen where the person's pleaded guilty or found guilty of murder, capital murder, the judges usually impose life without parole. Am I not right? I think rarely do I see, only in the recent one in Clarendon, that fellow who got 60 years. You remember, it was life, and you must serve 60 years before parole, okay? He had been charged, he pleaded guilty to 3 murders or 4 murders, and he got life for life, but he must serve 60 years before he could be released. That was one. Colleagues, the other one, non-capital murder, it is life imprisonment or a fixed term. The bill proposes 45 years, nothing less than 45 years. But the question then for both, for life imprisonment, I think Mr. Bailey just reminded me, if it's life imprisonment, they must serve 30, how many years? Before, just remind me, I don't have it before me. Sorry.
So if it's life imprisonment, they must serve at least 40 years
Before.
they're eligible for parole. If the term of mandatory, if a term,
Minimum mandatory. Yes.
if a term of imprisonment was given, then they must serve not less than 35 years.
Okay. So colleagues, members of it, these are numbers that we need to agree to or readjust in our recommendation to the Parliament. Sent again.
Just outside of the numbers that we need to agree to, because you, on many occasions, you spoke about the use of the plea bargaining procedure. And so we also have to consider what would be, in the essence of plea bargaining, the application of discounts.
No, discounts only apply under the Criminal Justice Amendment Act. No, we'll come back to that in a while, because it can be, if you get 50 years, for example, then a discount of 33 and a third would take it down to 32 years or so, okay? And then the judge could also determine what period minimum mandatory. Let me just
Can I just ask one other question in relation to that? Is there a minimum threshold that we are going to propose in relation to that?
We will.
Okay.
No. One of the good things, I don't know how many have been watching TV recently. The Trump lawyers, 3 of them have now pleaded guilty. And the reason why they pleaded guilty, by the way, if you followed it, they did not want to, they want to escape the RICO Act, where if they were convicted under the RICO Act, they could get up to life imprisonment. They didn't want to risk that. And one of the reasons, I might say, the little understanding I have of plea bargaining in the United States, 95% agree to plea bargaining because if they're convicted, the sentence is so high. Most times it's life imprisonment or 100 or 200 years. That is what the judges or the system up there used to, if I might say, coerce people to plead guilty. Now, once the defense and the prosecutor agree on a sentence in America, whatever is agreed is usually accepted. The prosecutor proposed something, and the defense bargain, and whatever is proposed, the court usually accept it. When I was tabling and proposing our act, we knew of the importance of a judge sanctioning. We didn't want it that the prosecution and the defense could just agree, and whatever they agree, the judge accepts. So in our pre-negotiation and agreement act, we say it is subject to the decision of the court. So if the court accepts what the prosecution and the defense agree, no problem. But you will see within the act, if the judge thinks that the sentence was too low, the defense can withdraw from the plea agreement. If the judge thinks the sentence was too high and wants to reduce it, the prosecution can withdraw from the plea agreement, or they can negotiate further before the judge. So this Plea Negotiation and Agreement Act, I hope, will be utilized more if we send that signal in these sentences. you understand that if you go to trial and you're found guilty, then not only would you get whatever sentence is imposed, but you must serve 20, 25, 30 years before you get. And the good thing about the Plea Negotiation Agreement Act now is that whatever the court, if you don't use, and if the prosecution is not a part of the sentencing process, then whatever sentence is imposed, if the prosecution doesn't agree, they now have a right of appeal on sentence. So colleagues, on those two, we can make some decisions. And so I don't know who would like to, you can say we agree with what is in the bill, or we can adjust it as the case may be in our recommendation. No, I just want to emphasize for the record that what we are proposing is for the committee to agree to make that recommendation, hopefully by consensus. But bear in mind that the accused can escape from what we are proposing if they come with a plea and there's an agreement between the defense. And naturally, we would hope that the court and the prosecution, no doubt, will use what we are proposing as a guide. In other words, they can't just ignore, let us be frank, what is the minimum mandatory or what is the sentence being proposed for murder. It is a guide, but certainly in saving the court time, normally they get some benefit from what would normally be the sentence in the event that they were found guilty of the trial. Senator
Minister,
Sinclair.
what you had asked Mr. Bailey to give some guidance in relation to the period that was being proposed. And you just mentioned two, which was 50 and you said 45?
No, different. For capital murder,
Capital murder, it's 50.
is death or life imprisonment. If life imprisonment, the bill proposes that the accused person should serve at least 50 years.
50.
So that's one area.
That's one.
The next section is, if it's non-capital murder, it is life imprisonment or a fixed term. If life imprisonment is imposed, then they must serve 40 years, Mr. 40 years?
Is it 40? 40 or 40?
40.
40, okay.
But if a fixed penalty is imposed by the court, it must be 45 or above. And they must serve at least 30 years, 35 years. So, I mean, this is a matter for us to either agree to these figures or we can come to a consensus what we recommend to Parliament. Is that clear? Now, having said that, we also have the section 42 to look at, because if the person, just listen carefully, colleagues, if the person don't want to have anything to do, then just come and they say, I plead guilty. I'm not in any bargain with the prosecution and the victim's family and no social inquiry report. I come and I plead guilty, okay? Then if they do, what we're saying is that life imprisonment in both capital and non-capital should be deemed to be 50 years. But they must serve at least 30 years. Is that the position, Mr. Bailey? They must serve, the minimum, they can't go below 30 years. Right. That using the Criminal Justice Amendment Act 42. I must tell you, I had a long debate with my team whether we should, because, you know, my position is to just remove Section 42 in relation to murder, go to the Plea Bargain and Negotiation Act. But my team at the ministry said, no, leave it alone, because there are some persons who don't want to, the defense, so no, I don't want to have anything. I just pleaded guilty. And so once they plead guilty, then the question is, you apply the Criminal Justice Amendment Act, which, by the way, happens quite a bit now, too. Sorry, go ahead.
So the proposal that we have, Minister, is that if it is that the individual pleads guilty, the judge cannot sentence that individual, or the judge cannot apply a discount that goes below 30 years. So that is his minimum that he has to work with.
No, if they plead guilty, to capital, it's life imprisonment.
As it stands, capital murder is not treated with under the provisions of the Criminal Justice Administration.
It's just
There's an exclusion. So it says that this part does not apply to circumstances of capital murder. So we're treating just simply with non-capital murder under Criminal Justice Administration Act.
Okay.
Do forgive me, I'm a little confused.
No, and we need to clarify everything.
The amendment which I'm seeing here is that the Act, Section 42F of the Principal Act is amended by deleting the words, a term of life imprisonment shall be deemed to be a term of 30 years.
No, 50 years.
No, the deletion. We're deleting that where it says, and we are substituting, a term of life imprisonment shall be deemed to be a term of 50 years where the offense is murder, and 30 years where the offense is an offense other than murder.
Right.
So I'm a little bit confused about the second application of 30 years where the offense is an offense other than murder. What are you referencing in that amendment?
In the Act, no. There's just a general provision, and it just says life imprisonment shall be deemed to be 30 years. So there's no delineation between if the offense is murder, or if it's a rape, or anything else. So what we thought was necessary was to do that delineation, that the same starting point in respect of murder should not be the same starting point in respect of another offense. So we did that delineation, and we increased the starting point in respect of murder. So it's now 50 years as opposed to 30 years.
Right.
No, we're maintaining the starting point in respect of everything else. So we'll remain at 30 years.
Okay. Any other comments, colleagues? So let's get some decision. So in relation to capital murder, death, life imprisonment, if it is life imprisonment, where the bill must serve minimum mandatory of 50 years. Do we agree with that, or do you have any adjustment upwards or downwards? Can we say a consensus for capital murder? Agreed? No objection? Well, let's hear Senator Motley, what you're saying.
Amendment. First of all, what you're telling me is that the Criminal Justice Administration Act does not apply to capital murder. That's what you just said. But when you're going to a term of life imprisonment, what you are actually doing is that you are bringing the sentence up to the proposed for capital murder.
No, please, careful.
So what is the proposal for capital murder that we are contemplating now?
No, remember no.
Sir, I'm not saying that I'm not wrong, but in my mind, if I'm going to participate in a decision, and I have some reservations. So what is the proposal now which you are asking us to contemplate for capital murder?
For capital murder, at the moment, it is the sentence is death or life imprisonment. If life imprisonment is imposed, we are increasing the figure, minimum mandatory to be served, from 20 to 50.
Right.
For capital murder.
Yes, but that's why I'm complaining about the way in which I'm seeing the amendment.
No, no, Senator Motley, bear in mind that the Criminal Justice Amendment Act is different from the OAP Act, where we're looking at the sentence and the minimum mandatory to be served. The Criminal Justice Amendment Act, like the plea bargain, plea negotiations and agreement act, comes after if the person pleads guilty. Right. Right.
As a way of explaining what is intended with the amendment to Criminal Justice Administration Act, more specifically 42F. 42F is really treating with what the court deems to be a sentence of life. So the court is just regarding a sentence of life as it concerns murder to be 50 years. And it's then saying...
And this is non-capital murder.
This is non-capital murder, since we already established that it's not concerned with capital murder under the Criminal Justice Administration Act. So essentially what happens is the court says, I'm sentencing you to life imprisonment, but now I'm going to apply the discounts because you have pled guilty. And in applying the discount, it says, because I've sentenced you to life, what does life start at? What is life really? So it says 50, then it applies the 33 and a third, and then applies the discount and bring it down.
Understand it, but what I'm saying, if it's 50 applies, you have a distinction in law between capital murder and murder. If 50, if you are saying that you are increasing the mandatory minimum to 50 years for capital murder, then you go to the Criminal Justice Administration.
No, please.
If I'm pleading, no,
you're
but there is a confusion,
because you're
okay, so let me put it differently.
You're overlapping them.
But you have to consider one impacts the other. Because if I go and I plead guilty to murder, my starting point, the starting point which you're giving me to the judge is 50 years, which really applies to capital murder.
Please, Senator Motley.
No, sir, but you're not thinking about it. That's why you're not hearing me.
Let me help you.
Okay.
In relation to capital murder, if you plead guilty, or if you're found guilty of capital murder, it's either death or life imprisonment, and the proposal of the bill, you serve a minimum of 50 years. If you're found guilty for non-capital murder, you can either get life imprisonment or a fixed term. If you get life imprisonment, and if you plead guilty and the judge says this will be life imprisonment, but since you plead guilty under Section 42 of the Criminal Justice Amendment Act, this life imprisonment for which you would be sentenced for non-capital murder, we start out at 50 years. No.
Is there a distinction for the starting point between capital and non-capital?
No. They're totally different. Totally different.
Yeah.
For capital murder, if you're found guilty, forget the date.
The lowest you can get is 50.
Right. You can get life imprisonment,
yes,
but you must serve at least 50 years.
The highest you can get is 50.
That's for
Under the bill. For capital.
Capital.
Right. No. For non-capital, the law as it is now, if you were being sentenced to life and you pleaded guilty, you say life is equivalent to 30 years and you start at 30 years. We are saying no, it must be increased. Life should reflect. We can say 50 or 60 or 80, and you start out at that. The proposal is to start out at 50. So if you start out at 50, then you can get a 33 and a third percent discount.
So what I'm trying to understand...
That is when you plead guilty,
Yes, what I'm trying to understand. So you still start out at 50?
You don't have to. No. If you plead guilty...
Yes.
To non-capital murder, Remember, the judge has a choice.
Yes.
The judge can say, for this, I would sentence you to 8 years. But since you pleaded guilty, I'm giving you a 33.33% discount, so it brings it down to 50.
So what I'm trying to get, if I plead guilty to the non-capital, what would be the incentive?
Yes, the judge must make a decision whether he imposes life imprisonment or a fixed term. If he decides to impose life imprisonment, he says, since you plead guilty, I'm starting out at 50 years.
Right.
And then he works on the basis of whether at the first opportunity you pleaded guilty, you get 33 1/3. If it's when the trial starts, you might only get 25% reduction.
So you are removing the fix and creating an incentive to negotiate down.
No, it is the option of the judge for non-capital murder. If he pleads guilty, the judge can say, because of the nature of this act,
Yes.
if you had been found guilty, I would have imposed life imprisonment.
Life imprisonment. Got that.
But because you plead guilty, I am starting out at 50 years. You are with me? Now, the judge could also say, because of the circumstances, I would have given you 45 years, which is a fixed penalty, which is, we say that should be the minimum. Okay? Mm-hmm. In all sincerity, we could say for non-capital murder, a term of at least 50 years for non-capital murder. We can say that, because life imprisonment would really be starting at 50 years. But the act as it is now provides for life imprisonment or a fixed term. If it was life imprisonment, the present law says you must serve at least 15 years, minimum mandatory. And if it was a fixed term, you must serve at least 10 years. We thought that was too low for the minimum mandatory. Why we went for 50 years, when you plead guilty, because if it is less, then it affects the section that says you must serve at least 30 years. In other words, section 42E, which says that you must serve at least 32 years if you're found guilty. Okay? Or if you're fine. So all that happens for non-capital murder, because there are two options, life imprisonment or a fixed term. If the judge says, yes, when you look at the nature and circumstances of this offense, I would have sentenced you to life imprisonment. And having done so, he then has to say, since you pleaded guilty, say at the first opportunity, we're reducing it by 33 1/3. But you can't reduce life imprisonment by 33 1/3, so you have to figure, you must start with a figure. Our proposal is to start at 50 years. And so you can start with the 33 1/3. If you later in the trial, you might only get 15 or 20 or 25%. So that is how, because the reason for this idea of the 50 years is because the Criminal Justice Act is making the proposal of the 33 1/3 or 25%. So you have to give life imprisonment a figure for the judge to start with.
Okay.
All right? But the judge could ignore that and say, sentence is 60 years, and therefore, since you pleaded guilty, we take off 20 years because you pleaded guilty, so we start at 40 years. You have been in prison for 3 years, we go to 37 years, but you must serve at least 20 years before, you can be considered for parole. All right? So we understand, hopefully then, the sentence Now, the other point to note, and this is where we have agreed that 50 years must be served for capital murder. No for minimum. For non-capital murder now, what is the minimum mandatory that should be served? We have it there that it should be 35. We're coming to your thing soon, right? All right, so colleagues, I'm going to ask you and urge you to agree on those figures. And the reason why I'm saying, and I will emphasize it, the accused can escape these minimum mandatory, these figures, if he comes forward with a guilty plea, either under the Criminal Justice Amendment Act or under the Plea Negotiations and Agreement Act. But these figures should be sufficiently threatening that the offender knows that if they're found guilty of a trial, they will serve these minimum mandatory. Okay? Having said that, colleagues, if we agree, we can now go back to our main contention. Sorry. No. Well, I don't hear an objection.
Yeah, so can I say?
Sure.
So I want to take you back to the recommendation of the Office of the Public Defender, which you read. And that observation was that the proposed increases outlined in the bill range from 260 to 350%, 260% to 350%. And the proposed percentage increases are extreme. The proposed increases are, however, they say, consistent with the legislators' expressed intention to increase the mandatory minimum sentence for murder to make it especially punitive. It is, however, not one that the OPD supports, bearing in mind our infrastructural issues and lack of ability to provide meaningful rehabilitation to our incarcerated. So stop there. The Office of the Director of Public Prosecutions, for whom, which we all hold in high regard, makes the point that there's nothing wrong with nothing that appears to be in discord with the relevant laws and procedures. But they do go on to give a caveat. They say homage should be paid to the fact that the prosecution now enjoys the right of appeal and in recent times have played an integral role in the sentencing process by way of submissions and the procurement of victim impact statements. The importance of this active role now being undertaken by prosecutors is to highlight the need for flexibility in the sentencing exercise as depending on the nature of the offense, the offender, and the public interest, the submissions may vary. I basically will state that I recognize the need to send a strong signal to the society about how the legislators feel about these offenses, and that the most significant way that one chooses to do so is in terms of the time for incarceration or the fine. Those are the two options that we have available. However, I find the increase which is proposed to be very dramatic and unsupported by any data. Minister, they would say in court that you have made a submission without authorities. I would like to ask, before I give my opinion, if there is anything that shows where punishment and rehabilitation, punishment and impact on the society intersect. In other words, have we done any kind of evaluation to find out if the proposal should be an increase of 100%, say? I picked that a percentage rather than a term of years. On what basis is it that we are saying that we feel that we feel that 50 years is the most appropriate sentence in these circumstances, moving, as the Office of the Public Defender says, to 350%. I know that you have said many times that the public has been howling and calling for the death penalty, but you personally don't agree with it.
Well, I don't support the death penalty.
Yes, and I understand, therefore, that you can be at variance with what the public is calling for. Because the response is not simply from you to the public. Because if you responded for the public, you could say, well, I don't like the death penalty, but the public is calling for it. So I know that you have taken a measured approach to this. And in it, you have taken account of the various positions which have been articulated. Now, all I'm asking for is some kind of indication as to where all the concerns intersect. And I only close by saying, if you're sentencing me to 50 years, please hang me. Don't sentence me to 50 years in this situation in the prisons. Just hang me and let me get it over and done with. Because to me, that's a sentence worse than death.
All right. Well, my view, Senator Motley, that sentence must reflect as much as possible public sentiments and the public interest. And I don't agree with the death penalty, but I recognize that why the public is clamoring for the death penalty is that they want to see the accused, now convict, put away for a long time. In other words, if you can't put them in their grave with hanging, they must be put away from the society for a long time. So you can't ignore the fact that if the victim and the victim's family believe that a man who has killed one of their loved ones, that in 15 or 20 years' time, he might come out and laugh at me. I mean, to speak loosely, the truth of the matter is that the public is saying a man who has taken a life don't deserve to enjoy too much of his life and in the society. And that is why when we look at the minimum mandatory, and I'm not saying that for non-capital murder, because non-capital murder has a rainbow of circumstances, okay? So that if members want to recommend a low minimum mandatory to be served for non-capital, it's a matter for members. But I would still maintain that for capital, that minimum 50 years, it should really be life without parole. And that is what the judges have been sentencing. We can even remove the 50 years, you know. You found guilty for capital murder, life without parole. But we have said, in the case, the judge can say, serve 50 years, which, with respect, Senator Motley, is exactly as you say, life without parole. They should remain in the prison for life. No problem. But I do believe, and this is where I personally could be flexible for non-capital murder. Minimum 45-year sentence, but in terms of how much time they serve in the prison, I could encourage some flexibility there, because maybe after 20 years or 25 years, they might be so, I mean, no, I'm not saying we should move from to 35 years, which is what is recommended, you know. But to the extent that they get 45 years, Minister Williams, bear in mind, you know, if you put the minimum mandatory that they serve at, say, 20 years, to give you an example, if when they go out and they engage in any act that breach their parole, one of the conditions is that the crime was committed in Clarendon, say, you must go to Clarendon. And, or, you know, you must visit the families of the victim or something. And if they breach that, they could come right back to be sentenced to continue to serve the remainder of their sentence. So don't ignore the fact that there's such differences in the type of murders that can be committed, which might come out in the evidence if it's a trial. That the court might say, well, instead of, yes, you get in 45 years, but you must serve 25 instead of what we are putting, 35. If you want to stick to the 30 or 35, I have no difficulty, but I'm saying we could recommend to Parliament either what is there, something less, something more. It's for the committee to make that decision, okay? So, Senator Mott, do you see my position? Yes. Go ahead.
Thank you, Mr. Chairman. I am just concerned that every time when lawmakers sit to consider sentences for persons who are guilty, that we continue to send this message of lenience. And that's not what the public wants at all. Somebody who has committed murder, the most egregious, I mean, you took away somebody else's life. Why are we even considering whether or not you should come back into society?
No, but Senator Motley, you know, no, you say, no, the truth of the matter, no, Senator Motley.
I want to give her an example.
No.
I want to give her an example. If a young girl is being raped every night by her stepfather, she's over 18, so we remove that. She is being raped every night by her stepfather.
First of all, with due respect, it's a bad example.
No, but you haven't allowed me to finish.
Because that's provocation right away. It took the manslaughter right away.
No, because provocation would mean that she would have to kill him in the act.
Yes. Sorry?
Provocation would mean that she has to kill him in the act.
No. With due respect.
That's not self-defense.
No.
Respectfully.
No.
Respectfully.
No.
It is not self-defense. And you should know better than that, because you know the rules of self-defense.
No, with due respect, Senator Montley, we have to.
But you have not allowed me to complete my.
No, we have to.
But you.
No. Bear in mind, we must always bear in mind, colleagues, that there are many charges of murder where, based on the circumstances, there could be diminished responsibility or provocation that immediately takes it away from what we are considering. Let's hear it. Turn on the mic.
Example. Saying that provocation, it converts the offense of murder to manslaughter. Yes. And so if you plead guilty under those circumstances, you're not going to be sentenced for murder.
Quite.
Because there's a defense. The only complete defense to a charge of murder is self-defense, which means that you must be acting to defend yourself or acting because you apprehend some and fear that there's going to be an attack on yourself. Right. So I don't need to go into any examples because I think this very discourse should indicate to the Minister of Education that murder and murder are not the same.
No,
that there are circumstances where, although you have taken a life, and we all decry those acts. We all decry them. But although you have taken a life, there are exculpatory things which arise. And even the office of the DPP is trying to point this Joint Select Committee to instances where the judge ought to be able to take into account some mitigating circumstances. She has reminded us that you, Minister, were the one who piloted the bill to give her the right to appeal against sentence. And she has used it effectively and judiciously. I am not saying that they must not be increased, you know, Minister. Let me make my position clear. I just think that the increases, and we have been getting a lot of criticism about how we approach increases generally. The increases are just too great. That's what I'm saying, that they are not reasonable. They are not grounded in any kind of data. They are emotive. They are a response to say, but they have committed the most egregious act you can commit in your life. You have taken somebody's life. That is not how the parliament must operate.
And my response, though, sentimentally, would be, bear in mind, when you're charged and convicted for murder, to the best of my understanding, there's very little mitigating factors. No, when you're charged and convicted for murder, you have very little mitigating factors. Because if somebody spit on you, if A spit on B, and B smart, and the next day you kill that person, you may say, but you had time to cool down. But if the court or the jury or the prosecutor feels that you are still smarting under that act, a good prosecution may well accept manslaughter for the simple reason you are still smarting under the provocation. So although the provocation should be immediate, most cases will tell you, if in fact you are still smarting under the provocation, and the reason I'm using that example of a girl who is raped, who finally sees the offender and kills him, then it may well be, I could not take it out of my mind that he's the one who raped me 2 weeks ago. And I think a good jury would acquit her based on provocation, because she was still smarting under what was done to her. Fine. So we can't solve all the problems here. Then,
I wanted to be on record that I'm not against an increase, but as Senator Motley just said, I believe it is too much, and there is some confusion in terms of capital and non-capital that we really need to get right. For me, I'm not a legal mind. No, just a minute, Chairman. And we need to get it right for me to be able to make any kind of conscious decision in this matter. This matter is dealing with people's life. It is not anything that we can joke with. And in respect to all the recommendations, we are talking about public opinions. But I would believe that all the recommendations that have come here has formed part of public opinions. And therefore, they need to be taken into consideration.
Member Daly, I don't think there can be much objection to the actual figure, like death, life imprisonment, or even the fixed term of 45 years. Where I think yourself and Senator Motley are looking at is the minimum time to be served where, in fact, you are found guilty. Fine. Or for that matter, where you're found guilty. Because if you pleaded not guilty, the minimum time could be much less. At the moment, it is 30 years, 35 years for life if the person was sentenced to life imprisonment. For non-capital, right? No, if the person is tried and convicted.
So we're looking at our proposals, Minister.
Right,
so the proposals are... no.
It is moving, it would be moving from...
So the law now, Minister, is if it is that you're sentenced to life imprisonment, your mandatory period that must be served is 15 years. If you're sentenced to a term of imprisonment, the minimum time that you must serve is 10 years.
Right. So what is happening, colleagues, the present law is that for non-capital, if you're found guilty, you could be sentenced to life imprisonment, and the judge could not, the minimum mandatory is 15 years. If you're sentenced to a fixed term, then the minimum mandatory is 10 years. We have moved it from 15 to 40 and 10 to 35. The question is, if you don't agree, what is your proposal? I'm not saying, if you say instead of 40, make it 30, instead of 35, make it 25, if that is your recommendation, let's discuss it. You see the point I'm making? Let's discuss it. All I'm really saying, because once we agree that for non-capital it's either life or 45 years, the question is, what is the minimum that they should serve before they're considered for parole? At the moment, it is 15 and 10. We think that both 15 and 10 are too low, especially in light of the Firearms Amendment Act, where it is 15 years. You understand? So if you just bear that in mind. So, you know, I'm not going to force you to make a decision. I was hoping we could make the decision, but we come back another time. And you give me your final figure. Is that okay? No, turn on your mic, turn on your mic, turn on your mic.
So what you're saying is that we must reflect on it and we can suggest some different,
Yes.
different.
So what we're really saying is that
Below the 50 or below.
No.
That's
No,
what
one
I
second.
want.
No, one second. For capital, the minimum is 50 years. If you're found, if you're given life imprisonment, would you like to reduce it, and by how much?
That's what I was asking.
Right. For capital. In other words, the person would get life imprisonment.
Yes.
But the minimum to be served, the bill says 50 years. You can return and we discuss it. If you say 5 years, we say go away with that.
And that is the one that is presently 15 years.
No, so
20.
So Senator Motley, we want a consensus where we can send it to Parliament without Parliament flinging it back in our face, okay? At the moment, it is 50 years for capital to be served. You want to reduce it by 5 or 10 years? Minister Williams, if they say that you must serve 40 or 45 years, is a matter we can discuss, okay? For non-capital, life says, if you get life imprisonment, at the moment it is 40 years. You want to reduce it by 5 or 10 years? Matter to be considered. If you get a fixed penalty, you must serve 35. You want to reduce it by 5 or 10 years? Let us discuss it. Agree? But bear in mind, don't bother come with too much reduction. Too much reduction. I mean, I can understand we take over 5 or 10 years and we discuss it. All right, but colleagues, listen. We have another more important, very important one to deal with, the children, yes. So sorry.
Chairman, thanks for that. Thanks for the time to give this some more consideration, but I wondered whether you can assist me in providing some guidance as to the reason why 50 years was chosen, proposed in the first place.
Well, basically, to be frank with you, when we discussed it at Legislation Committee, we felt that we must make it quite significant. So we send that message, and what the public been clamoring for, that the offender, having been convicted, should really stay in prison for life. So we started out on the basis, death, which is still on the statute book, life imprisonment without parole, which is the usual imposition of most the judge. So we said, well, suppose they don't put life imprisonment without parole. What could be a figure? No, I'm not saying whether it's 50 or 45 or 40 is a matter that we can make that recommendation. You get me? Obviously, less than that would almost be flying in the face of what the public interest is demanding.
Thanks for that, Chairman. And I was just going through the documents submitted by the DPP's office, and I believe that if we look at the document in detail and the sentences, including the appeal, then it provides a good guidance for us, a scientific guidance, if we may say. And we can add to it, we can read it. But I believe that this document is very insightful and can provide the best guidance for us to come up with a term.
And that is why I am leaving it for you to give it further consideration. And we come for one further final meeting, and we make, because we have had a good discussion, okay? If you notice, I'm not going to force it down your throat.
Thank you, Mr. Chairman. Mr. Chairman, I'm seeking some clarity from the technical team. In particular, the amendment to sections 42E and F of the Criminal Justice Administration Act. While we move these penalties, can you just confirm for me, we have not disturbed 42K. So ultimately, my computer just went down on me. Ultimately, a person charged and convicted of whatever the penalty is that we set, whether it's 50 or 40 years, would still be able to access 42K, in which case the judge is there. If the court determines that the sentence is manifestly excessive and unjust, then the court has the option of sentencing the person to the minimum penalty, which we are saying would be 50 or 40 years, whatever number fits in there.
And send it to the Court of Appeal.
And issuing them a certificate to go to the Court of Appeal to appeal the sentence because it's manifestly unjust. So we still have, and this wasn't so clear in my mind all along, Minister, let me finish. We still have the option of accessing the Court of Appeal in circumstances where we may be convicted of the minimum mandatory penalty that we're seeking to impose here. So there remains, and this is the confirmation I want, there remains an avenue for a defendant in the circumstances where the mandatory minimum is unjust or excessive. You're confirming yes to that?
Yeah, the answer is yes.
Yeah, okay.
Yes.
So my second question, Minister, do we have in place, because I think it arose, I can't remember which one of my colleagues had asked it, do we have in place the accessibility to legal aid for these kinds of appeals under 42K?
Definitely.
We do? Mm-hmm. Okay. Thank you, Minister.
Mm-hmm. In other words, as I've said, for any matter before the Supreme Court and the Court of Appeal, our legal aid normally grant a certificate. Sorry, who wanted to ask again? That's okay? Mm-hmm. All right, colleagues, we have another matter, the question of and I know the Ministry of Education team, they're here to assist us where we can. No, you can't leave us yet.
And when I came, sir, I did indicate to you that I had to leave
well,
early.
since we might not make a final decision,
yes,
no.
Yes, thank you.
But we need to have further discussion on the matter, okay?
Yes.
Because there were a number of issues which we had asked the correctional services, and they responded, the questions were responded to, and it was on your table. Now, where we left off last time was that we indicated, and I had indicated, that where a child, bear in mind, and the people have misinterpreted this, for sentence of murder, if the child is below 15, that is 12 to 14, it does not come under the penalties which we are now proposing. It still remains under the Child Care and Protection Act. But once you reach 15, 16, 17, the common law, by the way, was that once you reach 15, 16, 17, you're tried and convicted and sentenced like an adult. That was always the position at common law. But the Child Care and Protection Act now look at all juveniles from 12 to 17. But we are not considering 12 to 14. The sentence of the court is a matter for the judge. Okay, we are not dealing with this. But in our legislation, which for the Child Care and Amendment Act, it's your bill, Minister, we are saying for 15, 16, 17, the position we discussed last time was that if the child is convicted for capital murder, then they should be sentenced to life imprisonment with a minimum period of 20 years to be served in a penal institution, in some institution. Sorry? Life imprisonment, and you said 20 years. Yes. No. That's what is being proposed. What it is now, Minister, I'm sorry, Paul, what is the present if children convicted of capital murder now? What is it now?
So Minister, the thought is the penalties under the Offences Against the Persons Act apply to the child.
That is
the
correct.
only limitation is just in respect of 12 to 14, and that there's a limitation of 25 years prescribed.
And so what we're looking at, colleagues, the present law is that, and SG and Mr. Bailey, just confirm if I'm correct. If you're 15, 16, 17, and you're found guilty of capital murder, you're sentenced like an adult would be sentenced. Is that so? Go ahead.
So, Minister, as
One
per...
second. Yes.
No, I was just interjecting, Minister, to say that Section 78 of the Offences Against the Person Act, of the CCPA, makes it very clear that there can be no sentence of death, but that the child is liable to be imprisoned for life. I do have a question, though, because it goes on to say that my understanding in any event is that this applies to any child, but there is a proviso that a child who is 14 years and older can be detained in an adult prison if the judge finds it appropriate. So the inference I'm drawing from that is that it would apply to any child who is convicted of murder, but the ones who are below 14 can't be detained in an adult facility. Yes, and 78, 3, I think.
So what should be noted in our colleagues? When I propose for capital murder that the minimum mandatory be 20, was a concession, because the present law would be 50 years, they would have to serve 50 years. But because it's a child, we're saying, no, it can't be the same. It should be much less. No, it was. We said that for a child, 15, 16, 17, that was convicted for capital murder, that they should at least serve 20 years. Okay. Now, that is a matter for us to agree on, or no, where we didn't get to last time was where the child was convicted for non-capital murder. And, sorry. Your technical team, Ministry of Education, did you people have a look at that? You had a look at and have any suggestion? No, all right. Colleagues, yes.
Mr. Bailey, is there any mandatory minimum sentence for any other offense that would include a child? And if that is so, what would that be?
Sorry?
Oh, yes, there are other offenses. So, for instance, there is the case of the fire marshal that we spoke about, and that was a shooting with intent case. And the mandatory minimum was applicable. There is also...
And what is that?
50, it
That was
15.
15. That's 15 years.
That's 15.
As it stands now, with the Firearms Act, the mandatory minimum penalties are applicable to children.
Okay.
So my understanding is all mandatory minimum penalties that we have prescribed in law would be applicable to children, save for if it is that they are between the ages of 12 and 14.
Okay.
So actually, between 12 and 14, even for murder, they can't be sentenced to more than 25 years. That's the present law. So, but that is 12 to 14.
Yes, yes.
So we're not discussing 12 to 14.
Yeah, and I understand that.
Yes.
I asked the question because I wanted to have in my mind a distinction between those other offenses and what we are proposing for murder, being 20. Capital murder.
Well, one of the reasons last time, because why I said 20 years, for capital murder, was that there are many, like Tafari, where for wounding, the minimum was 15 years. Minimum mandatory was 15 years, wounding.
Right.
And also under the firearms offenses, the minimum mandatory is 15 years. So to put 15 for capital murder would really...
Yes.
So, and that's why I said 20 years last time. But for non-capital murder, we need to look at that too. No. Sorry, member.
Mandatory was always in the rules for children.
No. What was
when that come into being?
No, what was happening is that once you reach 15, you're not only charged, tried, but sentenced like an adult. So what we're trying to do is really to reduce the effect of what we are proposing, these high sentences for adults, to say since the person is 15, 16, 17, further consideration should be given as to what would be the minimum mandatory to be served. Because if you say 25, 30 years, which is what we were proposing in the earlier acts, you could see that to impose that on a child, 15, 30 years, for example, would definitely seem excessive for a child, right? So that is why we wanted to carve out, which still has to be dealt with by the CPC, that for capital, 20 years, but for non-capital, we can either say 15 or 20 years, and it's a matter for us to make that recommendation.
If I would be privy to say something about the report that you have from CAD, can I?
Sure.
In terms of the age limit that I see here, between 11 to 14, in terms of children who they said have psychological problems that have been, it seems very low. I do not know if those are just who they have diagnosed or if they have done any assessment on over the children overall, or is just those who comes to their attention?
I suspect they're dealing with persons who come within the institutions. Yes. No, who are there? Who? No, their figures here, Member Daly, is based on children who they had to deal with.
But I'm just saying, probably it is not for this, but I'm extremely concerned about an overall assessment in regards to children in these facilities in terms of testing and to look at what has caused some of the behaviors.
You know, Member Daly and colleagues, I will not deny that in examining these bills, a number of presentations were made and information became available of some concerns, which we will express in our report, okay? I'm not going to ask for a decision, no, but colleagues, we can have another meeting, shouldn't last more than an hour, where we just agree simply on figures. Is that okay? I mean, I thought we could do it now. I thought today would be the last, but I would be the, you know, I would like persons for us to have a consensus, okay? So we're going to propose another meeting, and the next meeting would be to approve the minutes. Last week, today would be the third minutes that we would approve, but we want to meet as soon as possible. What date do you have in mind? Next week, Wednesday? Next week, Wednesday at 10 o'clock? Okay? Wednesday, 1st of November. Next week, Wednesday, and we come to a final position so we can sign up. We're also going to ask the CPC to look at some provisions in relation to the non-capital murder for children. Colleagues, I want to thank you for being very receptive and participate in the discussion, and to thank the technical teams from Law Reform, CPC, Ministry of Justice, Ministry of Education, the Office of the Children's Advocate, and the AG and SG and Miss Mesada. Thanks again, members. Can I have a motion for adjournment? Sorry. Oh, sorry, yeah. 10 o'clock.
First, 10 o'clock.
Unless you want to make it 10:30. Actually, you know, it ought not to be a long meeting. So why don't we just say 11? No, 10:30. All right, 10 o'clock, 1st of November for the next meeting. Meeting adjourned.
in current affairs using state-of-art tools on Kolkata, India. It was wonderful experience be with international community and tech training. I'm implementing in my work wherever I learned. During my training, I visited a lot of places in Kolkata and I enjoyed Indian hospitality and I love their food and culture. I want to visit again. Thank you very much to India High Commission and Gulf of India.
I undergo a course